Hello, today we're going to be talking about chapters 2 and 3. And chapter 2 mainly talks about just the definition of law and the basis behind it for the most part, and the sources of law. Which just breaks down to critical thinking skills, legal literacy, understanding that the law is dynamic, not static, real world problems, just interpreting right from wrong, and then it goes on to talk about the different schools: natural law school, sociological school, and the sources of law, which they've created in the U.S. Constitution, and 3 direct sources of law and 1 indirect source. The legislative branch is the maker or creates of the laws. The executive branch is the enforcer of the laws, and the judicial branch is the interpreter of the laws. The 4th indicator source of law is the administrative agencies. Statutory law is made by the legislative branch of government. Case law resulting from judicial interpretations of constitutions and statutes. I thought the criminal law and civil, it talks about the different kinds of law, with the criminal law, which is composed of federal and state statutes prohibiting wrongful conduct ranging from murder to fraud. So I knew that before I read the chapter. And then there's civil law, which law governing legislation between 2 private parties. So a dispute, most cases over like money. Public law dealing with relationships of government to individual citizens. And private law, dealing with the enforcement of private duties. These are usually concerned with contracts and things of that nature. Substantive law, which just creates and regulates legal rights. Oh, that's the contract law, okay. The procedural law sets forth the rules of enforcing substantive rights in a court of law. Cyber law, which governs the law of the internet and things that have technology basis. Then we'll go on to chapter 3. Jurisdiction is the power of the court to hear a case and render a binding decision. So the authority pretty much the court has. A venue where a case is brought, usually the county of the trial court, prescribed by state statute. And it talks about the attorney-client privilege, which is whatever information pretty much you tell your attorney, they can't go for incriminate you and tell other people, because that's your privilege as them being your attorney and them working for you. And then the work product doctrine provides that formal and informal documents prepared by an attorney in conjunction with a client's case are privileged and not be revealed by the attorney without a client's permission. So So these chapters mainly just talked about the basis of law, where they originated, some cases associated with it also. And it just breaks down the foundation of law, really. So I thought I learned a lot from this chapter because I am still learning about law because I'm not very familiar with it. So thank you.